All rise. The Court of Appeals Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for argument in Peoria 44 versus Edwards et al. Let's begin with introductions of counsel for the appellants.
Your Honor, Kirsten Copeland for Mrs. Edwards and the Rise appellants.
Thank you.
Brianna Reinberg on behalf of Peoria 44 LLC.
Thank you very much. Let me go through some preliminaries here. Let me advise the counsel and the parties that we have carefully reviewed the briefs. We have read the pertinent portions of the record, and we've conferenced the case. So we're familiar with the basic facts, and you might like to take that into account in your remarks today. Each side has 20 minutes. The appellant may reserve time for rebuttal. When you go to the lectern, if you would like to do so, and let us know how much time you'd like to reserve for rebuttal, we'll try and make sure we don't poach on your time and that you actually end up with that time. We are recording the proceedings today, both audio and video, and so although you've introduced yourselves to us, when you go back to the lectern, if you would please restate your name. That way anyone who watches the audio or listens to the audio or watches the video, they'll know who's speaking. And I think with that, we'll go ahead and begin.
Thank you, Your Honors. Again, Kirsten Copeland here on behalf of the appellants, Mr. and Mrs. Rye and Mrs. Edwards, who's in this case both individually and in her capacity as trustee of the family trust. Your Honors, I think the issues in this matter are really pretty straightforward, and if anything, have become more simplified over the course of the briefing. And I want to make a couple of overarching points, which is that the lease and the addenda under which Peoria 44 is seeking to hold the Rise and Mrs. Edwards liable are actually subleases. And the reason I bring this to the court's attention is to make the distinction between subleases and assignments. In this case, each sublessor, by way of the whole series of addenda that were executed to the lease, they each entered into separate contractual relationships, not only with each other, but also with the landlord. And as sublessors, both the Rise and Mrs. Edwards retained not only a privity of contract with the landlord, but they also retained a privity of estate with the right of re-entry and the possibility of reversion should any of the subsequent subtenants breach the lease. And I think that's really the critical distinction, at least legally, in terms of the structure of the contractual arrangements in this case.
Was that distinction argued in your response to the motion for summary judgment?
It wasn't specifically argued, but I want to bring to the court's attention that this setup is undisputed. We did make the point that we are dealing with subleases and that there is a right of reentry and potential reversion of the leasehold interest, and that's been undisputed in this case.
On that point, I noted in the briefing in the trial court and also in the briefing here that you had made the point that Ms. Edwards and the Rise did have a right of reentry. I also noted that you hadn't cited anything, and so what you're saying today is that this is as a matter of law because it's a subtenancy relationship, not because of any particular provision in the lease?
That is correct. There is no specific provision in the lease. It's really simply by the nature of sort of Hornbook law of the nature of a sublease.
I didn't see any provision either.
Right.
Okay.
You're correct, Your Honor. There is no particular provision. So based on that, undisputed relationship, we're here really because Peoria 44 nevertheless denied the Rise and the Edwards their fundamental property rights and terminated their respective leasehold interests without notice, the notice that was in fact required under the express terms of the lease. And I would really like to, in terms of my time up here, I would like to address primarily the notice issue. I'm planning anyway to rest on the briefs in terms of Peoria 44's burden of production and whether or not it met it, although of course I'll answer any questions that Your Honors may have. So one of the key issues here is that this case in all respects, I would argue, has actually transformed from an action for breach of contract, breach of a lease agreement for non-payment, into an action for breach of a lease agreement for abandonment. In effect, in its reply in support of summary judgment and now on appeal, it appears that Peoria 44 has essentially pardon the confusion, abandoned its original argument that the reason that it's entitled to terminate the lease was not because of a non-payment by my clients, but because of abandonment of the lease by one of the subtenants who came along after my clients. So, and I think I think the reason for Peoria 44's decision to do that is pretty apparent, because the lease terms are very, very clear that if you're going to terminate, if the landlord's going to terminate the lease for non-payment, it's not just the non-payment that is a event of default in the lease. It has to be non-payment after written notice. And Peoria 44 concedes in this case that notice was not given to all of the subtenants. In fact, I don't think there's anything in the record that even indicates that notice was given to the original defaulting subtenant.
Are you saying that their theory was simply non-payment in the motion, and then in the reply it changed to abandonment?
Actually, I would go a little farther than that. The original theory, as expressed in the original complaint, cited only non-payment, and they were very explicit about that. And in the reply to summary judgment, yes, it changed to abandonment. And now on appeal, they've effectively, again, I hate to use the double usage of the term, but effectively abandoned the non-payment as an issue, even on appeal. So I think for all practical purposes, that piece of it is dead.
And why is that important on whether we should affirm or reverse the summary judgment?
Because, well, for two reasons, Your Honor. In terms of the non-payment, I think it's effectively a concession that notice was required to all of the subtenants in order to hold any of them liable for breach of the lease agreement and to actually terminate the lease. The other piece of it is since they really haven't, argued that or supported that in the brief, now what we're left with is an issue of whether or not the trial court could have concluded that my clients abandoned the lease. I believe that's important for two reasons. One is that the issue of abandonment was not raised until the reply brief on summary judgment. Therefore, it was waived, and it would be an improper basis for granting summary judgment below. In addition, moving to the abandonment issue here on appeal, there are numerous issues that, as a matter of law, even if it had been raised in the original motion for summary judgment, I believe it would be incorrect as a matter of law to conclude that abandonment is a basis for terminating the lease as to the otherwise non-defaulting subtenants.
What would they be? What would those issues be on abandonment?
For example, Your Honor, as we cited in our papers, one of the issues on abandonment is there has to be a component of intent of some kind. And because there's no evidence in the record whatsoever that my clients in any way, shape, or form intended to abandon, meaning walk away from the leasehold interest, I think that it would have been improper to make that conclusion on summary judgment.
What about the party that was in possession of the property, running the business, and the evidence that the landlord presented in which that party basically shut the door and walked out?
Except I don't think there was any evidence of that. The allegation was, if I recall correctly, in fact, I think it was expressly pled in the complaint that they operated the business right up to and including the date of termination. That's what the confusion is, because the allegation is that they weren't paying rent. If I get the dates right, I believe it was from sometime in August 2010 up to and including the date of the termination letter, which I think was January 19th. So that was the original allegation in the complaint. Those two pieces then are mutually exclusive. You can't have a factual allegation that they were in fact operating the business and occupying the premises right up until the date of termination, but then at the same time argue that they've abandoned the lease. Does that answer your question, Your Honor? So ultimately, what we're dealing with is that Peoria 44 actually asserted, as Your Honor pointed out, only that the Mahoneys, those were the last subtenants, only that the Mahoneys abandoned the premises. There's no allegation anywhere, either below on the summary judgment papers or even here on appeal, that the non-defaulting subtenants in any way abandoned the lease. Peoria 44 also never alleged either, I apologize, Your Honor. Accordingly, abandonment can't serve as an event of default as to either the Rise or to Mrs. Edwards. In effect, what we're dealing with here are tenants that never actually were in default under the lease, and yet the lease is terminated as to them and they are now deprived of their right to re-enter, deprived the right to cure the defaulting tenant's breach. And that's inherently unfair, Your Honors.
Are the subtenants not considered to be the agent of your client?
I don't believe so, Your Honor, because, again, we're dealing with separate, both contractual privity with the landlord, and we're also dealing with still a separate property interest in terms of there's a new leasehold interest that's granted between the tenant and the new subtenants. I'm not sure I answered your question.
My question is that it seems like control of the premises has been to some extent relinquished to a designated individual, an agent, who has then engaged in activity. And the question is whether is that attributable to the principal?
And I would argue that it's not, Your Honor, because one of the things that those, the particular lease addenda did was reaffirm the rights and obligations in the original lease agreement as to the, I guess I'll call them sub-lessors, right? So the ones that are doing the relinquishing of the right of possession are nevertheless, according to those addenda, affirming the rights and obligations of the original lease agreement, which include the notice provisions. So I would argue, Your Honor, that there's no that agency, to the extent that it exists, would not, it doesn't make any sense, actually, to impute that agency obligation in a way that would deprive the relinquishing subtenants of the right to notice. And that's for practical reasons, too, Your Honors, is if your obligation is to cure a downstream tenant's breach, how can you ever do that unless you're made aware of the breach? And I think that goes to the heart of the good faith and fair dealing argument. So at the end of the day, in order to grant summary judgment in favor of Peoria 44, the trial court would have had to conclude either that the Rise and the Edwards were not entitled to notice, or that the Rise and the Edwards abandoned the lease. And there's really, as a matter of law, that's the basis of our appeal. As a matter of law, we argue that they are entitled to notice, and that's quite clear under the terms of the lease agreement. And that to the extent that we've now shifted to an abandonment theory, that there is absolutely no evidence in the record, nor is there even really any claim that either the Rise or the Edwards were the ones who actually abandoned. Therefore, there's no event of default that can be applied to them.
In your client's response to the motion for summary judgment, what facts were established by sworn testimony, affidavits, disclosure, whatever, that relate to these defenses? Were they all established?
With regard to, we pled the whole issue of notice is effectively pled both as an affirmative defense, sort of a prior breach type argument, but it's also an argument that they can't meet their essential elements of a breach of contract, because without an event of default, there's no breach. So it kind of moves both ways. So in terms of facts, yes, in fact, I believe that there's an affidavit from Annette Schlenz. There's also an affidavit from the Rise that they actually sought an opportunity to repossess the premises, restart the daycare center, and basically finish out the term of the lease, and that was denied. That issue not only addresses the whole, notice and opportunity to cure piece of it, but it also goes to the mitigation of damages issue, which is the only affirmative defense that was addressed in any way, shape, or form in the opening, in Peoria 44's opening motion. And it's frankly a little logically odd. Here you have this whole series of subtenants who are essentially there and available. The landlord knows exactly who they are, exactly how to get a hold of them. They have a breaching subtenant at the end of the line, and yet they don't contact any of these people to determine whether or not any of these people would be able to come back in, cure the breach, restart the daycare center, and finish out the term of the lease. It makes no sense, frankly. So Your Honor's point is not only it's not only an issue of notice and opportunity to cure, but it also goes to the obligation of the landlord to mitigate damages. I think I'd like to reserve the rest of my time, if I may.
May it please the Court. Good morning, Your Honors. Ryan Bird on behalf of Peoria 44 LLC, the appellee in this case. It's Peoria 44's position that granting of summary judgment is appropriate in this case. The appellee's motion for summary judgment stated a legal basis for a breach of contract claim, proved the breach, and proved its damages.
What about all the affirmative defenses that were raised, and how do you square what was not addressed pursuant to Thruston about the affirmative defenses in your original motion?
Well, under Thruston, Your Honor, it's my reading of that case that because the affirmative defenses are the burden of the appellants in this case, that once we prove a prima facie case of breach of contract, the burden shifts. And in Thurston, it specifically sets forth that Peoria 44 demonstrated entitlement to judgment. The appellants bore the obligation to prove their affirmative defenses. Peoria 44 was not required to negate the affirmative defenses in its moving papers.
Well, I think Thruston says that the moving party in this type of situation does not have to present negating evidence, but the moving party has to show that there is no evidence available supporting the affirmative defenses. So there is a duty on the moving party to, in good faith, pursuant to Rule 11, address the lack of evidence or the legal insufficiency of the affirmative defenses. And having looked at the motion here, I didn't see the landlord doing that.
Your Honor, those were addressed in the reply. In Thurston, the bank never even responded in the reply to the affirmative defenses. We also addressed mitigation of damages, and at that point...
Put aside mitigation for a moment. I hear you on that. But what about the other affirmative defenses? Doesn't Thruston really envision that the moving party needs to meet these both burden of production and burden of persuasion in its motion? Because after all, we have case law that holds the responding party doesn't even have to respond. And failure to respond does not entitle a party to summary judgment.
Well, Your Honor, I would assert that we did address those in the fact that we proved a breach of the contract. So the notice provision goes out the window because in this case, abandonment under 11.13 does not require notice.
Did you raise abandonment in your motion, your original motion?
We did. We raised that there was a breach of the lease. Exhibit J to our motion for summary judgment was a letter from the attorney on behalf of Peoria 44 LLC that specifically asserted that the landlord is exercising its remedies under the lease to retake possession due to abandonment, and specifically cited Section 3.5 and 7.4 of the lease. 3.5 of the lease defines what abandonment is under this lease. So even though the appellants are arguing there must have been some intention to abandon, that's not the requirement in this case, because when you read 3.5 of the lease, it specifically states that if the operator doesn't operate for a specific period of time, that's deemed an abandonment. So the letter and Exhibit J to our motion for summary judgment raised the issue of the reason for the landlord to exercise its remedies under the lease. So in that case...
So is the point that I can attach, I'm a litigant, and I can attach a bunch of exhibits that make some assertions, and that somehow constitutes argument in a motion for summary judgment?
When we argue that it's a breach of the lease, Your Honor, and specifically reference the provisions of that lease of which the landlord exercised its remedies under this case, all we have to prove is the existence of that contract. That's not in dispute. That there was a breach, and the exhibit specifically identifies what that breach was referenced in affidavits.
But I'm still struggling, and then we can move on with the motion's failure to even address the affirmative defenses here. I mean, for example, there's duress, there's lack of capacity, there's some additional affirmative defenses that I think the Rees made. They're missing an action in the original motion.
Well, Your Honor, that's because they don't. There's no issue of fact regarding these defenses.
But don't you have to say that? Don't you have to let the court know that, in your view, there is no evidence in the record, so they're factually unproven or unsubstantiated, so there's no conflict in the facts, or they are legally insufficient?
I would argue no, under Thurston, that we don't have to prove the negative, that we only have to prove the prima facie case of breach of contract.
So, Mr. Byrd, the way I hear your argument is that on behalf of your client, your obligation was only to show that there was no genuine issue of material fact relative to the claim brought by your client, and that this theory, the burden then shifted to the defendants to come forward with evidence showing a genuine issue of fact as it related either to your claim or to affirmative defenses that would help defeat the claim.
Yes, and I believe that's based upon Thurston, because the specific language in there says Peoria 44, the appellee, does not have an obligation to negate these arguments. They raised, for example, if they, in their answer to the complaint, they raise 8 different accord and satisfaction. Do we have to go through each one and indicate that there is no evidence to prove that when we prove the prima facie case? And the burden is on the appellant to prove that there is a genuine issue of fact in this case, not on the appellee. So when you look at the totality of everything, no notice was required under the lease as provided. In addition, there's no dispute that the appellants did.
Hold on for a minute, please. No notice was required because you were proceeding on abandonment
Yes, Your Honor, and
in the original motion?
correct. It's attached as Exhibit J. We're also asserting breach of lease, and I would argue to the court that the abandonment and the notice is merely a mechanism for the landlord to take possession of the property under that lease and to terminate the right to possession and exercise its remedies under 11.25 of that lease. It's not the abandonment of the lease creates an event of default. The lease specifically states no notice is required for an abandonment of the premises. As such, that is merely a mechanism for us, the Peoria 44, to take possession of the space and exercise its remedies. So, in essence, once that breach occurred, Peoria 44 exercises remedies, takes possession, and has the right under 11.25 to accelerate the rent due under that contract and to take possession and try to mitigate its damage. In this case, it actually mitigated its damages in a timely fashion. And there is no evidence from the appellants that what was done was unreasonable as set forth in Wingate and Next Gen Capital, that the burden is on the defendant or the appellant to prove that what was done was unreasonable. They would have had to have testimony from a broker, a real estate professional, to come forth and say that what Peoria 44 was unreasonable in this case.
Excuse me for interrupting again. Did you get summary judgment in your favor because the Mahoney's abandoned or because they quit paying? Possibly both.
I think it's both, Your Honor. The abandonment is, like I indicated, is merely the right for the landlord to take possession. There's still a default under this lease, which we pled and we proved. Nobody's paid rent. Nobody was in possession at the time the landlord exercised its rights. So when you look at it, that's merely the right to take possession. That doesn't eliminate the breach of contract case in this case. The appellants were given the right, as you see in the supplemental affidavit of Mark Ryan, to come back in and operate the premises, but they had to cure the default. They had to pay in full, and they all refused to do that in this case. So they were given an opportunity to re-enter, but they had to cure default because that's what was owed under that lease.
Forgive me, but I thought there was an affidavit, I think, from one of the subtenants who explained she wanted to go in and was told basically, no can do.
Well, in response to that, we submitted a supplemental affidavit from Mr. Ryan.
But isn't that a conflict?
It's not a material issue of fact, Your Honor, because
Really?
I would argue it's not a material issue because they have to cure a default before a defaulting tenant can come back into a space. There's nothing that would say that the defaulting tenant would come in and start paying rent. They could have defaulted again. So there's no obligation for a landlord to allow a defaulting tenant to re-enter the space. Once it's terminated, under that lease, they have the right to accelerate and there's no right of reentry.
You know, it almost strikes me, and forgive me, that this is somehow there's a catch-22 going on here. For example, Ms. Copeland argued that under legal principles applicable to subtenants, the subtenants here were entitled to re-enter. But of course, if they don't know about what's going on, they can't really exercise that right. So did they have a right to re-enter? Do they have a legal right to re-enter? Not under the lease, because there's nothing there, but as just a matter of general landlord-tenant law?
No, they do not have a right to re-enter because they are a defaulting tenant that the landlord terminated its rights under this lease.
But how do they know they're in default? You've defaulted the Mahonies. But these other subtenants, if they don't know, how can they be a defaulting tenant when they don't know there's any problems with the Mahonies?
The January 19th letter indicated that Mahoney had abandoned the space.
That's right. That's after the fact.
But is there, sorry, Your Honor, I didn't mean to cut you off.
No, go ahead.
There's no notice requirement in the lease that they have to provide notice to a subtenant that the current tenant is defaulting.
But then what is the meaning, what value does their right to re-enter have? It has no meaning then. It has no value if they don't know.
Well, they don't have a right to re-enter.
Before the lease is formally terminated, they had a right to re-enter, right?
They could have re-entered.
Okay.
It's their obligation as subtenant to monitor the person they sold their business to see if that person is paying rent. When they signed these addendums, they specifically agreed that they would be held liable under the terms of this lease. There's no obligation in that lease that the landlord provide them notice that Mr. Mahoney is defaulting. It's their obligation that they sold their business, and each time they came to the landlord to sell their business, the landlord agreed. However, he stated, you still have to remain on the hook for the obligations of this lease. But there's no obligation in the lease that we have to provide the prior tenant notice, especially in the case of an abandonment. As we indicated, I think the Peoria 44 has clearly proved the existence of contract. There's no depositions, no testimony that these contracts aren't enforceable. I think the lack of capacity argument was addressed appropriately in the brief. When Mrs. Edwards sold her business and bought her business, she agreed to be held liable at that time for the remainder of the term of the lease, which went through August of 2011. As such, capacity down the line would not have any material issue on the determination that Peoria 44 is entitled to its case. And I want to reiterate the fact that abandonment was addressed in the motion for summary judgment, that is merely a mechanism for the landlord to take possession of the space, and that once that occurred, the landlord has the right to exercise its remedies, which includes the amount sought in its damages claim. I think there's no dispute regarding the calculation of damages. There was no dispute regarding the mitigation of damages. There's no affidavits to contradict those, and as such, the summary judgment was appropriate and is appropriate in this case because there's no material issue of fact that the Mahonies abandoned the space. There's no dispute that they abandoned. There's no dispute that landlord exercised its remedies pursuant to that abandonment, and there's no dispute regarding the calculation of damages following the breach of the lease. I have nothing further unless you have follow-up questions.
Thank you.
Thank you, Your Honor.
Your Honors, Kirsten Copeland again on behalf of appellants. I think the issue here is the lease itself is quite clear that default for the default in the case of non-payment doesn't become an event of default. There is no breach of the lease agreement until there has been notice and continued non-payment. The argument
That is found where in the lease?
that is, I believe it's 11.1.
Right.
Yes, 11.1, Your Honor. It isn't, I don't think anybody disputes here. In fact, I'm quite sure nobody disputes here that there was some period of time where rent was not being paid to Peoria 44. The issue is that for the Rise and for Mrs. Edwards, the only reason that rent wasn't being paid is because they didn't know that there had been any kind of a breach for non-payment. Had they been informed back in August of 2010, when the breach initially occurred, which is taking the statements as true, they would have had the opportunity at that point to re-enter, to fire up the daycare center and continue paying rent. And ultimately, Peoria 44 would have essentially had no damages because they would have had a continuous business and payment of rent during that time. The problem is that Peoria 44 terminated the lease, excluded my clients from the premises without providing any notice or opportunity to cure someone else's breach, not their breach, someone else's breach. I'm pretty confident that there is nowhere in the papers that there is an allegation that at some point the Rise or Mrs. Edwards failed to pay rent after notice, which is the requirement, express requirement under the lease. So what Peoria 44 is essentially arguing is that that notice provision somehow goes away and is now inapplicable because of the addenda to the lease and the introduction of a subtenant into the contractual arrangement. I don't think there's any there's been no case law support offered for that provision, and in fact, that is contrary to the actual terms of the specific addenda, which basically reaffirm all of the terms in the original lease agreement, which has to include the notice provisions. So if they're going to hold my clients liable and hold to my client's obligations under the lease, then the obligations have to go both ways.
Well, there's no question that to be an event of default for non-payment, 11.1 or the section that deals with what is an event of default.
I think it's subsection C,
I think
or
that's
3,
right.
maybe it does.
Requires notice and an opportunity to cure.
Right.
Okay. But then we come back to abandonment.
And I agree that that's a different issue, and I would concede that there is no notice required for the landlord to re-enter and retake the premises in the event of an abandonment. The problem is the only way to do that under these circumstances is to impute the alleged Mahoney's abandonment to my clients. And on top of that, Your Honor asked about facts in the record. There are facts in the record that expressly contradict that assertion. In other words, the allegation that was made by plaintiffs in their complaint was that the Mahoneys continued to operate and occupy the business up into January of 2011. So there's no factual support in the record even that the Mahoneys abandoned the lease according to their own allegations. So I think the whole issue of abandonment and waiver of that argument because it's the only way that they even got to the issue of abandonment is by pointing to a single exhibit attached to the motion for summary judgment. No argument, nothing in the statement of facts, nothing like that. That whole issue aside, there's still contradictory factual evidence in the record even as to the Mahoney's alleged abandonment. And I would also then go, Your Honor, again back to the question of even if we were to concede, which of course we don't, even if we were to concede that the landlord had the right under the lease agreement not to provide notice technically, that to not do so would be a breach of the covenant of good faith and fair dealing precisely for the reasons that Judge Norris raised, which are how does anyone even know, how do any of the other subtenants even know that there's an issue? How can they even begin to exercise their right to reentry and repossess the premises if they don't know about the breach? The entity here who's in the best position to be fully aware of the breach is, of course, the landlord, because they're the ones that are supposed to get the monthly rent checks. When those don't show up, they're the ones who know instantly. To put the burden somehow on the subtenants to monitor, I don't even know how they would begin to do so. That is an easy thing for the landlord to do. Clearly, they knew where all the subtenants were because they did provide them notice of termination of the lease. So how difficult would it have been for them to simply send a letter back in August or September of 2010 and say, hey, the Mahoneys aren't paying rent. You know, you have your obligations under the lease agreement. You know, let's talk, come forward and reopen the business. Otherwise, we will. Then they have notice. Now you can default the remaining subtenants. But they didn't do that. Are there any other questions, Your Honor?
Maybe they didn't have to do that.
And I would argue that they did under the implied covenant of good faith and fair dealing. In fact, I do argue it.
Yes, but not under any specific provision of the lease.
Well, to be clear, we are arguing specifically that they do have the obligation under the lease agreement, that the lease is specific, that the notice provisions that each of the subtenants are entitled to don't go away. They aren't abrogated simply by the subsequent sublease. The sublease is really carving out a new leasehold interest. The privity of contract, the terms of the contract all stay the same. So our main argument is that the lease does explicitly require notice to all subtenants in order to hold them in default through an event of default under the lease. But even if Your Honors were to conclude that that's not the case, then it's still an issue in terms of application of the implied covenant of good faith and fair dealing, that the way that the landlord went about this really was inherently unfair, and that it was a reasonable expectation for the subtenants who were relinquishing their possessory interest to have notice if somebody else breached. Thank you, Your Honors.
Thank you very much. We appreciate your briefing and your argument today. We're going to take this matter under advisement and will issue a decision in due course. We're going to adjourn briefly so the bailiff can set up the courtroom for our next argument. Thank you very much.